In this regard, I will come down also, because the lower judiciary forums also are there. If any lower judicial forums have to be examined the matter, but without approaching the lower judiciary forums, if we will approach the High Court under Article 226 of the Constitution of India, then also High Court would deliver the judgment that go and approach the appropriate forum for get the justice. So then, of the state authority or state instrumentalities, without following the due process of law, without following the due process of law, without giving an opportunity, and violating the principles of natural justice, then and also violating the fundamental rights, more particularly Article 1421 of the Constitution. You all know very well that Article 14 is pillar of the Constitution. I didn't say this. One prominent justice has said in the AILU conference only, Honorable Justice Ujjal. Now, his lordship has elevated to the Supreme Court, discharging duties or holding the bench at Honorable Supreme Court. By Honorable Justice Ujjal has categorically stated that the Article 14 of the Constitution of India is pillar of the Constitution. If that has been violated or Article 21 is violated, then citizen is having ample right to approach Honorable High Court under Article 226 of the Constitution of India by filing the writ petition to issue the writ. Now I'll come to the PIL. సార్ చెప్తూనే ఉన్నాడు వస్తా పిఏఎల్ అని అంటే అసలు వస్తలేడని చెప్పేసి మీరు అనుకుంటున్నారు. పిఏఎల్కి వచ్చే ముందు ఇవన్నీ విషయాలు మీకు తెలిస్తే రేపు మీరు ఒక ఎమినెంట్ లాయర్గా మీ ప్రొఫెషన్ లోపల, ఈ నోబుల్ ప్రొఫెషన్ లోపల కోర్టుకు అసిస్ట్ చేసేసి ప్రజలకు న్యాయాన్ని అందించగలరనే ఉద్దేశంతో ఇవన్నీ మీకు చెప్పడం జరుగుతుంది. The first PIL instituted in the Bihar High Court in the year 1976 by Usanera Khatun versus State of Bihar. What was the subject on that? Many under trials prisoners are not being conducted the trial, and the under trial prisoners for the past several decades in the Bihar jails, so that many people are depriving their right to life and their families without any trial, lying in the jails, so that Usanera Khatun has instituted one PIL in the Bihar High Court 1976. That has been dismissed by the Bihar High Court. Then she has approached the Honorable Supreme Court. Honorable Supreme Court comprises with the prominent judges bench who were late V.R. Krishnayya, P.N. Bhagavat. Prominent judges, not only on that subject in Indian judiciary, both judges were prominent judges in providing to the justice to the public at large. The bench has examined the matter elaborately and extensively and directed the Bihar state government to conduct the trial in accordance with the law within the stipulated period and to provide the justice to the prisoners by protecting the Article 1421 of the Constitution of India. Subsequently, Maneka Gandhi case, you know very well that the right to life cannot be deprived without following the due process of law has been laid down. The right to life has been included, right to privacy also, right to journey also, right to livelihood also, all have been defined in the Maneka Gandhi case subsequently. The first phase of PIL, what has been examined, I would like to express before you that those rights are violated, specifically disadvantaged people in the society. More particularly prisoners, child labor, women, scheduled tribe people, marginalized people in the society were not able to approach the court by an individual to get the justice from the constitutional courts. Those rights are being violated and those are all in the society as public at large, so that the first phase of the PILs were entertained and provide the justices to these marginalized classes. The second phase of PILs were providing justice to the environment protection, corruption issues and good governance issues also. And the third phase of PILs began to involve policy matters and issues that within the domain of the legislature. And the fourth phase of PILs cases have been examined by to increase the judicial activism and suo motu action also, and also if you will write the letter, just my brother has said that brother Parthasarathi, brother Ramchandra Reddy has also categorically stated that if you write the letter, that has to be taken into the consideration if there is huge violation of the fundamental rights of the public at large, gross violation of the fundamental rights of the public at large, has to be taken into the consideration and to direct the registry to allot the PIL number to place before the appropriate bench to examine to provide the justice. Subsequently, even you have not been submitted the letter, you didn't write the letter to the Honorable Chief Justice, either to the High Court Honorable Chief Justice or to the Supreme Court Chief Justice, some instances which have been violated the fundamental rights by the state and its instrumentalities, gross violation of the public at large, courts are having ample power to take those cases as suo motu cases and to direct the registry to allot the PIL numbers and to place before the concerned bench as expeditiously as possible to examine the matter to provide the justice to the public at large in the incidents. These 4 or 5 phases have come from 1976 to 2025 in one part, and in another part also another part also we need to know and to examine also. Where in few incidents, somebody says that many incidents, but in few incidents have imposed a fine on the petitioners, where they have been filed the PIL to provide the justice to the public at large by examining the issues by the honorable courts. But those have been taken into the consideration as a abuse of process of law and imposed the cause. In another part also. One incident I would like to tell you. In the COVID-19 pandemic situation, one person has been filed the PIL before the Honorable Supreme Court that direct the central and state governments to provide the liquor by online booking to the homes, because the COVID pandemic situation has been seriously in the society. We are not able to go to the shops and to purchase the same, so that this PIL need to be entertained. Then the Honorable Supreme Court has been imposed a fine on the petitioner by dismissing that PIL 10 lakhs rupees. ఇది ఎందుకు చెప్పాల్సి వస్తుందనంటే ఎక్కడి నుంచి ఎక్కడికి పోయింది పిఐలు అనే విషయం మీద చెప్పాల్సిన పరిస్థితి ఏర్పడింది. అందుకొరకు చెప్పాల్సి వస్తాం. తర్వాత క్రమం లోపల in the year 1981, I think so, Bandhu Mukti Morcha, one non-government organization, has been instituted with PIL at Honorable Supreme Court to resolve the labor issues, more particularly bonded labor issues. Subsequently, one PIL has instituted in the Honorable Supreme Court, SP Gupta versus Union of India. 7 judges bench has elaborately examined the issue that what is the locus standi to file the PIL? Who has to file the PIL? When it has to be filed the PIL? How to examine the PIL? How to provide the justice to the public at large in the PIL? These are all issues examined by the Honorable Supreme Court, more particularly locus standi. 7 judges bench judgment of an apex court, that SP Gupta judgment categorically stated that a person acting bona fide and having sufficient reason will alone have locus standi to file the public interest litigation and to assist the court to provide the justice to the public at large. That has been followed in many cases, including in the year 1992 Janata Dal versus Chandrasekhar also, case also. Because of the locus standi, many cases dismissed in the various high courts and Supreme Court also. And which issues have to be taken into the consideration, which I already expressed before you few minutes back, that in various phases, various high courts and Honorable Supreme Court have been examined the marginalized people issues. The doctrine of health, the doctrine of right to livelihood, the doctrine of environment protection. There are many judgments delivered by an apex court, by constitutional bench judgments, like M.C. Mehta Olga Tellis, Menaka Gandhi, these are all landmark judgment of an apex court are delivered in the PILs only. You are all well known that the Subramanya Swamy judgment and Manohar Lal Sharma judgment, Swaraj Abhiyan judgment, Gaurav Kumar Bansal judgment, these are all judgments are in the marginalized people issues have been examined by the Honorable Supreme Court. In landmark judgments are there that more particularly in the environment protection, M.C. Mehta, who was the senior designated counsel in the Honorable Supreme Court, has filed many PILs. And Manohar Lal Sharma also, you know Manohar Lal Sharma's case, that natural resource allocation, 2G spectrum case, which is landmark judgments, have been delivered that. And subsequently, after Manohar Lal Sharma judgment, natural resource allocation judgment president reference has been delivered that 2012 NDCC page 1, which has been reported as landmark judgment. What law laid down in this, we want to know that. Natural resources have categorically stated in the 2G spectrum case that shall not be sold by the state or its instrumentalities without following the due process of law or action. The first natural resource has been defined in the judgment: land. Land cannot be sold, land cannot be allowed. One cannot be benefited on the state cost. It amounts to violation of the Article 14 of the Constitution of India. So that మనం చూసాం, ఆ ఒక్క గ్రౌండ్ ను ఆధారం చేసుకొని, ఆ ఒక్క జడ్జిమెంట్ ఆధారం చేసుకొని టిఆర్ఎస్ ప్రభుత్వం హైదరాబాద్ చుట్టుపక్కల భూములన్నీ అమ్మేసేసేసింది. మొత్తం ఆక్షన్ ద్వారా అమ్మాలనే దాంతో అమ్మేసేసేసి. అంతకుముందు అలాట్ చేసేవారు, ఎవరికి ఇష్టం వచ్చినట్టు వాళ్ళు అలాట్ చేసేవాళ్ళు. కొంచెమన్నా ట్రాన్స్పరెన్సీ దీంట్లో ఉంటుందనే ఉద్దేశంతో ఆ విధంగా జడ్జిమెంట్ డెలివర్ చేయడం జరిగింది. What is Swaraj Abhiyan judgment? This is a landmark judgment. In the year 2011 or 12, I think so, huge drought took place in the North India. Rajasthan, Gujarat, Bihar, Jharkhand and few more states of North India, huge drought is taken place years together. Pashuvula gadi kuda dorukadi. Then one PIL instituted in the Supreme Court, that's called Swaraj Abhiyan case. There the Honorable Supreme Court has categorically stated that continuous mandamus can be issued by the courts, which is integral facet of our jurisprudence. Which is integral facet of jurisprudence that has been used by me in the COVID-19 pandemic situation. First PIL I have filed in all over India in the High Court Judicature of Hyderabad, that to provide the treatment to the public at large, because health department totally failed to provide the treatment to the public at large in the state of Telangana. By the announcement of the Honorable Chief Minister that if you can use paracetamol tablet, COVID-19 pandemic, global pandemic situation, human being would survive. That's very adverse statement given by the Honorable Chief Minister, the then Honorable Chief Minister, in the Assembly or in press conference. Only 3 hospitals were notified for the COVID pandemic patients. Then we had moved the PIL to increase the hospital, to direct the government to increase the hospital from state level to rural level, and to provide the testing kits to the from 100,000 to lakhs which people are need in the state of Telangana, and to provide the ration and also for their day-to-day livelihood expenses, and also to provide the PP kits, glasses, N90 masks to the doctors, paramedical staff who are serving to the public at large by putting their lives on the public at large and serving the public at large in the COVID pandemic situation to cure the patients, COVID-19 patients under global pandemic situation. Why? ఎందుకు నేను ఈ విషయాలు చెప్తున్నా అంటే ఎప్పుడు ఎట్లా యూజ్ చేయాలి పిఐఎల్, ఎందుకొరకు యూజ్ చేయాలి పిఐఎల్, దానివల్ల ప్రజలకు మనం కోర్టును అసీజ్ చేసి ఏ విధంగా న్యాయము ప్రజలకు అందించగలుగుతాము అనే విషయాన్ని కూడా చెప్పదలుచుకున్నాను. అప్పుడు గాంధీ, కోటి, ఉస్మానియా హాస్పిటల్ నుండి డెత్ ఫీల్డ్ హాస్పిటల్స్ వరకు కింది స్థాయి వరకు 2 నెలల ఒకట నోటిఫై చేయడం జరిగింది. డే టు డే మానిటర్ చేసేసేసి ఇంకా మాతో పాటు చాలా మంది మిత్రులు కూడా తర్వాత రావడం, బిల్స్ లోపల వాళ్ళు కూడా అసిస్ట్ చేయడం, అట్లా తెలంగాణలోని చాలా మంది ప్రజల ప్రాణాలను కాపాడేందుకు ప్రయత్నం చేశారు. సబ్సిక్వెంట్లీ దేశవ్యాప్తంగా కూడా చాలా పిల్స్, సుప్రీంకోర్టులో కూడా చాలా పిల్స్ పడ్డాయి. ఆ విషయాలన్నీ మీ అందరికి తెలుసు. సుప్రీంకోర్టు ఒక ప్రామినెంట్ కౌన్సిల్ యొక్క బిల్లు తిరస్కరిస్తే ఆయన ఎంత బాధపడ్డాడు, దాని తర్వాత ఎట్లా కంటెంప్ట్ కేసు అయింది, ఆ విషయాలన్నీ కూడా మీకు జ్యుడిషియరీ హిస్టరీకి పోతే 20 తర్వాత పోతే తెలుస్తుంది. అవి ఇప్పుడు కాకుండా మరొకసారి మనం డిస్కస్ చేద్దాం. ముఖ్యంగా మనం ఎప్పుడు పిఐఎల్ ఫైల్ చేయాలనే విషయాన్ని ఇప్పుడు తెలుసుకున్నాం. మనం ఎప్పుడు రిట్ పిటిషన్ ఫైల్ చేయాలనే విషయాన్ని కూడా తెలుసుకోవాల్సిన అవసరం ఉంది. అండ్ ఇండివిజువల్ ఫండమెంటల్ రైట్స్ ఆర్ లీగల్ రైట్, సివిల్ రైట్ has been violated by the state or state instrumentality can file the writ petition, and the person doesn't have personal interest but having sufficient reason and acting bona fide, they can file the PIL to assist the court for provide the justice to the public at large. Distinction, this is the distinction. An individual rights have been violated, then writ petition. Public at large rights have been violated by the state or its instrumentality, then PIL. And the PIL locus standi must have been not having personal interest and having only public interest, sufficient reason and acting bona fide, then can file the PIL. Now I will come into the policy decisions. మనం చాలా మంది ఏమనుకుంటారు, that is policy decision, court would not interfere in this. That's wrong. Even it is either parliament or legislature has been enacted the acts by the exercising the power of the governments. Those provisions are being violated the fundamental rights. This has to be an important. Those acts are being violated by the fundamental rights. There we have right to file the either writ petition or public interest litigation also. You all know that Section 66A of IT Act has been violated the right to express their opinion under Article 19 and 21. In Sreyangal case, Honorable Supreme Court has been struck down the Section 66A of IT Act of 2000. And you were all known that Farmers Act, 4 acts brought by the National Democratic Alliance government in the last government, which are being violated the farmers' rights. Thousands of days were taken place protect at the Delhi by the farmers. Across the India were protested years together. Subsequently, Honorable Supreme Court stayed those farmer acts, 3 acts. Subsequently, elections season has come, then government itself has withdrawn the same. But those provisions were being violated the fundamental rights of the farmers, poor farmers in India, farmers in India. The provisions which are enacted by the parliament, depriving the right to livelihood, which is integral facet of the right to life of the farmers, so that it have to be struck down. The same was examined by the Honorable Supreme Court in the interior stage only as stayed those provisions of the Act. Subsequently, government has withdrawn. Now I will come into the policy decisions. Though the state government or central government has power to issue the policy by exercising their power which prescribed in the Constitution, because the supremacy is Constitution, the supremacy is democracy. This has been stated by an apex court in the Keshavananda Bharati cases. Constitution is more powerful rather than Parliament. It's having supremacy. Fundamental rights, basic structure of the Constitution, these are all cannot be amended by the Parliament. And even provisions, various acts enacted by the either Parliament or various state government legislative assemblies or councils, by exercising their power, if it is so arbitrary, also can be struck down. In this case, I would like to give one example of the landmark judgment of an apex court, Anant Ammal versus State of Tamil Nadu. In this case, scheduled caste lands were acquired for the public utilization purpose. One provision has been enacted by the Tamil Nadu state government by providing the compensation as installment wise, not at a time. This has been challenged by the aggrieved people before Madras High Court. Madras High Court was upheld the provision which has been enacted by the state government of Tamil Nadu. Argued by the same, preferred an appeal by way of the SLP before Honorable Supreme Court. Honorable Supreme Court struck down the same. It is so arbitrary because that land belongs to the scheduled caste and cannot be provided the compensation as installment wise. That would be violate the fundamental rights which ensured under Article 1421 of the Constitution of India. The right to livelihood is integral facet of the right to life, so that it shall not be deprived. It is being deprived by this provision, it has to be struck down. So now I will come into the policy. పాలసీ వస్తానంటుండే కానీ సార్ అసలే వస్తలేడు పాలసీ అని అనుకుంటుండే. పాలసీ డిసిషన్స్ మీద చాలా వాస్ట్ సబ్జెక్ట్ అది. మనం ఇవాళ తప్పనిసరి వాటి విషయాల్లో కూడా చర్చించుకోవాల్సిన అవసరం ఉంది. ఎందుకంటే ఎలక్టెడ్ గవర్నమెంట్స్ వాటి పవర్ను ప్రజల ప్రయోజనానికి ఉపయోగించకుండా ప్రతిదీ పాలసీ డిసిషన్ పేరుతోటి ఎట్లా ప్రజల ఫండమెంటల్ రైట్స్ ను వైలేట్ చేస్తా ఉందో మనం అర్థం చేసుకోవచ్చు. అందుకు కొన్ని ఉదాహరణలు కూడా మీ ముందు చెప్పేందుకు కూడా ప్రయత్నం చేస్తాను. The policy decision has been taken earlier state government of Telangana to shift the chest hospital to the Anantagiri and to construct the secretariat at Erragadda Chest Hospital place. Then it was unreasonable decision in my opinion, because four states people were taking the chest disease treatment at Hyderabad. Chest diseases infecting only to the poorest in the poor people, those who are not having nutrition food. గుడ్డు కూడా తినలేని ఆర్థిక సామర్థ్యం లేని అతి పేద నా బడుగు బలహీన వర్గాల ప్రజలకే చెస్ట్ డిసీజెస్ వస్తాయి. అటువంటి సమయంలో కూడా చెస్ట్ హాస్పిటల్ తెలంగాణ పక్కనే ఉన్న కర్ణాటక, పక్కనే ఉన్న మహారాష్ట్ర, అదేవిధంగా ఆంధ్రప్రదేశ్ ప్రజలకు కూడా ట్రీట్మెంట్ ఇస్తూ ఉంది. ఎక్కడనో అనంతగిరి గుట్టలకు తరలిస్తే అది వాళ్ళందరికీ కూడా ఇబ్బంది అవుతుంది అనే దృష్టితోటి. తర్వాత హెరిటేజ్, ఇది ఈ గవర్నమెంట్లు కట్టినవి కాదు, నిజాం ప్రభుత్వాలు కట్టినవి. నిజాం సాగర్ ప్రాజెక్టు కానీ, పోచారం ప్రాజెక్టు కానీ, ఇవన్నీ ఇట్నే హాస్పిటల్స్ కానీ కొన్ని అవన్నీ కూడా వీళ్ళు కట్టినవి కావు. కానీ వీళ్ళు వాటిని ఎట్లా డ్యామేజ్ చేద్దామని అయితే చూస్తారు ఈ ప్రభుత్వాలు. అది ఎందుకంటే ప్రైమ్ ప్రాపర్టీస్ మీద వాళ్ళ కన్ను పడ్డదంటే దేన్ని కూడా వదిలిపెట్టరు కాబట్టి. అదంతా దట్స్ ట్రూ. అప్పుడు కోర్టు ఇంటర్ఫేర్ అయ్యేందుకు సిద్ధపడలేదు. కానీ హెరిటేజ్ ప్రొటెక్షన్ యాక్ట్ ఒకటి ఉంది. ద హెరిటేజ్ మాన్యుమెంట్స్ విచ్ ఆర్ హ్యావింగ్ మోర్ దెన్ 100 years సర్వీస్ ఆర్ ఏజ్ ఆఫ్ ది మాన్యుమెంట్స్ shall be protected under the Heritage Monuments Protection Act 1955. And the same was stated by an apex court in Viceroy Lodge, Simla versus Union of India. సిమ్లాలో ఒక వైస్రాయ్ లాడ్జి ఉండేది బ్రిటిష్ ప్రభుత్వం ఉన్నప్పుడు. ఎండాకాలం లోపల వైస్రాయ్లో అక్కడికి వెళ్ళి విశ్రాంతి తీసుకునేది సిమ్లాకు. దాని తర్వాత హిమాచల్ ప్రదేశ్ ప్రభుత్వం దాన్ని కూలగొట్టడానికి ప్రయత్నం చేసినప్పుడు ఆ కేసు ఒకటి సుప్రీంకోర్టు ముందుకు వచ్చినప్పుడు అండర్ ప్రొవిజన్స్ ఆఫ్ దట్ యాక్ట్ has been protected and the same as applied here and it has already been declared as a heritage monument so that it cannot be struck down. Subsequently Eramanjal building also protected in this way. I can come to the policy decisions. One Bridgeman Law case is there in Honorable Supreme Court. The larger bench was examined. In the Supreme Court are three categories of the benches would form. One, directly bench would consist two judges. Larger bench comprises with three judges. Constitutional bench minimum 5 judges and more than 5 judges also can comprise in the benches and according to the subjects, to examine according to the subjects. This Bridgeman Law judgment was a larger bench judgment. Bridgeman Law was one of the district judge has appointed in the fast track court and terminated their services. Then larger bench, he has filed the petition before the Honorable Supreme Court on behalf of the all employees. It's not PIL, but in the mean of PIL. PIL when cannot be entertained. Also one more ingredient is there. In the service matters, there cannot be instituted the PIL before the Supreme Court. In service or High Court. Because aggrieved party only should constitute the writ petition but not PIL. In this matter, there are 10 of judgments of an apex court, including Duryodhana Samu versus State of Orissa, has categorically stated that though petitioner doesn't have any grievance in the petition, has been filed the PIL that has been struck down by an apex court. Because you doesn't have any grievance in this, the people who are having grievance should come before us to get the justice. Here in the case that Bridgeman Law case, fast track courts have been constituted by the 11th Finance Commission to conduct the trial. Many cases are pending across the India, had given the power to the state governments to constitute the fast track courts and appoint the judges and staff to conduct the trial day-to-day basis, so that fast track courts have been constituted. Subsequently, commission period was over, the judges were and staff were terminated from the service. Then petition is instituted before the Supreme Court that has been examined by the larger bench of an apex court. In this para number 70 to 80 in this judgment, Honorable Supreme Court has long laid down, even it is a policy decision, is amounts to unreasonable, divorce of the provisions of the Act, and it amounts to the struck down, divorce of the provisions of the Act, unreasonable, so arbitrary, behind provisions of the Act, if it has been taken the decision that cannot be valid in the eye of law, these four ingredients can shut down the policy decision which has been taken either by the state government or central government, its instrument of this. And the same was reiterated in the Jindal versus Union of India also. This is also one of the landmark issues. ఎందుకంటే పాలసీ డిసిషన్స్ అనే పేరుతోటి ప్రజల యొక్క ఫండమెంటల్ రైట్స్ కానీ, లీగల్ రైట్స్ కానీ, సివిల్ రైట్స్ కానీ ప్రభుత్వాలు వయలేట్ చేసినందుకు రైట్ లేదు. అటువంటి పాలసీ డిసిషన్ను ఖచ్చితంగా స్ట్రక్ డౌన్ చేయొచ్చు. ఇన్ ఆంధ్రప్రదేశ్, తెలంగాణ హైకోర్టు రీసెంట్లీ one matter has been examined and to deliver the judgment. The journalists who are working in the district headquarter, mandal headquarter, state headquarter, and in various newspapers, and categorized the newspapers 5,000 to 10,000 publishing, 10,000 to 20,000 publication, 50,000 to 1 lakh publication. Under these circumstances, earlier government in the year 2014, one policy decision has been taken up. Those who are working in the big newspapers, from the mandal level to state level, were provided the accreditation cards and not provided the accreditation cards to the small papers, journalists, those who are working at district level, mandal level. The same was examined by the Honorable Division Bench of High Court of Telangana and struck down the same. It's discriminating the journalists, those who are working state and mandal level in the small newspapers and the big newspapers in not providing the accreditation cards. You are all well known that accreditation card means it provides the some beneficiary schemes. Ticketless travel can be done, and welfare schemes can be provided to the journalists like health cards and housing allotments. These are all. They violating the fundamental rights of the journalists who are working in the small papers at district and mandal level. That cannot be valid in the eye of law. Where the Honorable Supreme Court in a canon of judgment has categorically stated that all equals cannot be treated unequals. Unequals cannot be treated equal, which is basic structure of the Constitution. Though there is having power to classify, but equals cannot be treated unequal, unequals cannot be treated equal. On this subject, many judgments are there. Constitutional bench judgments. From 1952 to till yesterday, many judgments have been delivered, like D.S. Nakala and E.P. Royappa, Minerva Mills. Many judgments are there. Subramaniam Swamy, 2014. Policy decisions also can be struck down when the four ingredients would attract to that policy decision. The government or its instrumentalities do not have power to issue such kind of policy decisions. Courts are having power to judicial review to struck down the same. ఇప్పుడు నేను in another part I would come now. I would like to express that specifically Balwant Singh judgment. ఈ విధంగా మిస్యూజ్ అవుతుందనే పేరుతోటి 2015 లోపల సుప్రీంకోర్టులో కూడా ఒక జడ్జిమెంట్ వచ్చింది. దట్ జడ్జిమెంట్ హ్యాస్ బీన్ provided the powers to the all High Court registry to frame the rules to file the PIL. మన పార్థసారథి గారు చెప్పారు కదా, ఒక PIL ఫైల్ చేయాలంటే ఇప్పుడు చాలా విషయాల్లో కూడా మనం అఫిడవిట్ ఇచ్చి ఉన్నారు. అవి ఆ రూల్స్ ఫ్రేమ్ చేసింది. ఆ రూల్స్ లోపల ప్రతి విషయం కూడా నీకు ఈ సమాచారం ఎక్కడి నుంచి వచ్చింది అనేది క్లియర్గా నువ్వు అఫిడవిట్లో చెప్పాలి. అదేవిధంగా ఒకవేళ ఫైన్ ఇంపోర్ట్ చేస్తే నువ్వు కట్టగలిగే సామర్థ్యం ఉన్నదని కూడా అఫిడవిట్లో చూపెట్టుకోవాలి. అదేవిధంగా నీకు పర్సనల్ ఇంట్రెస్ట్ లేదు దీంట్లో అని కూడా ప్రూవ్ చేసుకోవాలి. అదేవిధంగా కోర్టు నీకు ఎప్పుడు కూడా ఫైన్ ఇంపోజ్ చేయలేదు అని చెప్పేసి కూడా అఫిడవిట్ నువ్వు ఇవ్వగలగాలి. ఇవన్నీ రూల్స్ ఫ్రేమ్ చేసేందుకు కారణం ఏంటంటే బల్వంత్ సింగ్ జడ్జిమెంట్ 2015 వచ్చిన తర్వాత ప్రతి హైకోర్టు ఇట్స్ ఓన్ రూల్స్ హావ్ బీన్ ఫ్రేమ్ టు ఫైల్ ది PIL. ఇప్పుడు చాలా పెద్ద ప్రాసెస్ PIL ఫైల్ చేయాలి. ఆ ప్రాసెస్ లోపల ఆఖరికి ప్రతి విషయాన్ని కూడా మనం అవసరం అనుకుంటే రిజిస్ట్రీ దగ్గరికి పోయి ఎక్స్ప్లెయిన్ చేయాల్సిన పరిస్థితి. హౌ ఇట్ ఈస్ కమ్ అండర్ ది పబ్లిక్ ఇంట్రెస్ట్ లిటిగేషన్. Why it doesn't come into the private writ petition? Where is locus standi? And how many cases registered against the petitioner? These are all should reveal before the court. Then only PIL will be number and to be placed before concerned honorable division bench. రోజు రోజుకు లా సరళీకృతం కావాలి, అవి ప్రజలకు ఉపయోగపడేట్టు కావాలి. కానీ ఇక్కడ ఆ జడ్జిమెంట్ ద్వారా ఏమైంది అని అంటే చాలా స్ట్రిక్ట్ ప్రిన్సిపల్స్ హావ్ బీన్ ఇన్స్టిట్యూటెడ్ బై ది రిజిస్ట్రీ సో దట్ many people are not coming forward to file the PILs. It's also one of the disadvantage to the marginalized people to get the justice, in my opinion. ఇంకా రీసెంట్ ఇంకొక జడ్జిమెంట్ డివిజన్ బెంచ్ చేసింది ఒక 1 year క్రితం. ఎంటిటీ రైట్స్ ఆఫ్ ది పిటిషనర్. ఇది ఇంకా విచిత్రం. నువ్వు ఒక PIL ఫైల్ చేస్తే ఒక సమస్యను నువ్వు గుర్తించినావు, దీన్ని రాజ్యాంగబద్ధంగా చట్టబద్ధంగా పరిష్కరించదలుచుకున్నావు. ప్రభుత్వాలకు చట్టబద్ధంగా రాజ్యాంగబద్ధంగా డైరెక్షన్స్ కోర్టు ఇస్తే తప్ప ఆ సమస్య పరిష్కారం కాదని నువ్వు భావించినావు. అయినా నీకు అవకాశం లేని పరిస్థితి కల్పించింది ఆ జడ్జిమెంట్. వాట్ ఆర్ యువర్ ఎంటిటీ రైట్స్ టు ఫైల్ ది PIL? నువ్వు ప్రజలకు ఏమన్నా ఇంతకుముందు సర్వీస్ చేసినావా? సర్వీస్ చేస్తే ఎటువంటి సర్వీస్ చేసినావు? ఆ సర్వీస్ ఎందరికి చేసినావు అనే విషయాన్ని కూడా నీ అఫిడవిట్లో పొందుపరచాలనేది ఆ జడ్జిమెంట్ యొక్క ఉద్దేశం. ఆ జడ్జిమెంట్ తెలియని యంగ్స్టర్స్, నల్సార్ నుంచి కానీ లా స్కూల్స్ నుంచి వచ్చిన వాళ్ళు కానీ కొంత బాగా ఇంట్రెస్ట్ ఉంటుంది కదా పబ్లిక్ ఇంట్రెస్ట్ లిటిగేషన్ చేయడం ద్వారా. నోబుల్ ప్రొఫెషన్ లోపల ప్రజల మనసులు ప్రజలకు సర్వీస్ చేయడం ద్వారా వాళ్ళ మనసులు చూరగొనడం, అదేవిధంగా ప్రజలకు సర్వీస్ చేయడం ద్వారా తృప్తి పొందడం, అదేవిధంగా మార్జినలైజ్ పీపుల్కు న్యాయం అందకుంటే అందించడం ద్వారా ఒక ప్రొఫెషన్కు వన్నదేవడం, రాజ్యాంగాన్ని రక్షించడం. రాజ్యాంగంలో పొందుపరిచిన హక్కులను రక్షించడం అంటే న్యాయం అందించడమే కదా. Where the depriving the fundamental rights, principles of directive state policy or other constitutional, legal, civil rights are being violated by the state and its instrumentalities, center and its instrumentalities, there we are ready to assist the court to provide the justice by the honorable courts, it's also basic structure of the Constitution, and to protect the Constitution and to provide the justice to the public at large. It should have every advocate as primary motto in the profession, being noble profession. కానీ ఇప్పుడు ఇచ్చిన జడ్జ్మెంట్ అది వైలేట్ చేస్తాము. ఐ అబ్జర్వ్ ఇన్ ది వేరియస్ పిటిషన్స్. పాపం వీళ్ళు వచ్చి చేస్తూ ఉన్నారు. చేయగానే ఆ చీఫ్ జస్టిస్ ఒక జడ్జ్మెంట్ ఇచ్చేసేసి కోర్ట్ ఆఫీసర్కి ఇచ్చేసి చూసుకోమని చెప్పాను. Because they don't know the judgment as delivered by the division bench of this court. That's binding on them. Sometimes it would adversely affect on the petitioner counsels or petitioners also, either to withdraw or to impose the cost. Then advocate should come forward to submit arguments before the court that I will get the instruction from the client. Kindly have it after 2 weeks. Spontaneously we need to submit there, because tomorrow we are going to become advocates and coming into the noble profession. Many students and many advocates also are here. If honorable division bench would pose question on you that why should not be dismissed your petition basing on this judgment, you do not have any entity rights, because coordinate division bench of this honorable court has been delivered the judgment, it's binding on you. Immediately, spontaneously you need to submit arguments before the court by giving great respect to the court that I will get the instruction from the client, kindly have it after 2 weeks. I am ready to get the instruction from the petitioner, then I will submit the arguments before your lordships. If he has any public service, I will submit by way of the additional affidavit before your lordships to satisfy this honorable court for examining this petition to provide the justice at public at large. You need to submit the arguments spontaneously, then you will get the relief. Subsequently you will call your client and this query posed question on me by the division bench. To resolve this query by you, what I need to do, then you will get the instruction from your client. Next date of hearing, you will appear before the court and to submit effective arguments on query of the honorable court. Isn't it? So that there is a vast subject of the PIL, 1 hour, 2 hour, it cannot be resolved. In another occasion, we will discuss vast subject of PIL and how to provide the justice by the judiciary by assisting to the courts by us, our advocates, our party in person. We will know that in future seminars, if possible, if the organizers would invite me to deliver lecture on the vast subject in future, definitely I would attend. Thank you for giving this opportunity. Thank you one and all who have been patiently heard my lecture. Thank you. If any queries are there, you will be able to ask me one by one. If possible, I would resolve. Thank you.
మీరు క్వశ్చన్స్ ఏమైనా ఉంటే రాసి పంపించండి, మొత్తం కలిపి ఒకేసారి చెప్తాను. అందరూ ఇంకేమైనా క్వశ్చన్స్ ఉంటే పంపించండి. సరే అడగడం.
Sir, good afternoon to you and good afternoon everybody. Am I audible? Okay, na? So firstly, thanks for a very nice lecture on the PIN. I'm attending such lecture for the first time. I just thought I'll ask this query. Maybe somebody might have asked earlier also. what is seen from the PIL is that our legislature always seems to be attacking the constitution, or especially at the basic structure. Basis. Okay. Okay. What I have been noticing is for the past 1.5 hours.
అక్కడే మాట్లాడతాయి అది ఆఫ్ చేసేయండి.
Yeah, am I audible now? And so what I was noticing is that for the past 1.5 hours, we are seeing that government is always trying to target or trying to violate the constitution, the basic structure of the constitution. Because courts have a duty to provide justice to the marginalized and also the needy people. There are some cases where people are wrong. But at the same time, when it comes to PIL, mostly it has been because of the policy decisions of the governments. Now, instead of trying to tackle the the policies which have been violating the norms of the constitution, I just want to ask, do we have any provision where when the law is being formulated, when the acts are being formulated, they should be, under the law ministry, a panel of lawyers or maybe eminent judges who should be able to scrutinize that particular, policy or law from the standpoint of violation to the basic structure of the constitution, because that is where all the problem will come. There can be any change in the policy, maybe because of changed socio-economic environment or maybe strategic environment. But the fundamental rights which are being guaranteed to the citizenry of any country have to be maintained at all cost. So I just want to, sir, request you to throw some light on this point. And the other thing is, when we are doing it, now there was one case which you told that people will be penalized and so many conditions which have been put where new lawyers, I am also one of the budding lawyers, maybe another year or so. So if at all I want to do, I do not have any experience of fighting for any marginalized society, but yes, I have all the required enthusiasm and motivation to fight for them. But I will be ineligible because I don't have a history of past struggle. So how do we tackle this in the future, sir? Thank you.
What is the good news, sir? So, unless do hard work, unless do join in the office of the senior, should learn the basic of law, how to file the petitions, how to file the PILs, how to file the other petitions before the court of law, either lower judicial forum or constitutional courts. We can't get the experience. So that we need to learn the law means we should do the practice in the various courts along with your senior. Because your senior was filed many cases, your senior was argued many cases, your senior was